Justice Emeka Wete in his ruling held that the fact that Mr. Kyari and 4 other police officers that are facing trial with him did not escape when Kuje prison was recently attacked by insurgents was not enough to prove that they would not jump bail once they are released from custody. He dismissed the argument that Kuje jailbreak constituted exceptional circumstances which the court should consider to review its earlier ruling that denied him bail. The development the defendants relied upon did not fall with the purview of Section 162 and 163 of the Administration of Criminal Justice Act to warrant the court to vary its subsisting order. Justice Wete held that since the NDLEA has not closed its case, both Abba Kyari and his co-defendants could interfere with some of the vital witnesses and undermine their prosecution if released on bail.
The application we made to court is application for review of bail, considering the threat to their life and the recent jailbreak.
Has been denied bail before now. I have a bail application, further bail application before the court, but from the posture of the court, it appears that nobody will be granted any bail. However, I do not want to accuse the court or undermine the position of the court. But the proper thing to do is that if I feel that we are aggrieved, why not? We will go to appeal.
On 7th March 2022, Mr. Abba Kyari and 4 other police officers pled not guilty to charges of conspiracy, obstruction of justice, unlawful tampering and dealing with cocaine. With this refusal of bail, the defendants will remain in the custody of the Kuje Correctional Facility. The court adjourned to 19th October for a limited hearing.
On the 12th of July 2021, the Department of State Security invaded the home of Sunday Adeyemo, popularly known as Sunday Igboho. The invasion led to the arrest of 12 of his aides, while the Yoruba Nation agitator managed to escape arrest. Following the raid, Sunday Igboho, through his lawyer Yomi Aliyu, sued the federal government and demanded to be paid a sum of 500 billion naira for damages caused by a breach of his fundamental rights. The Oyo State High Court in September 2021, through Justice Ladinro Akintola, declared the raid conducted by the Department of State Service on the residence of Sunday Igboho in Ibadan as illegal. Justice Ladinro also ordered that the DSS pay 20 billion naira to Igboho as exemplary and aggravated damages and described the DSS action as an arbitrary aggression and prejudices against Igboho. Now, Justice Muslim Hassan, while delivering judgment on the case, said the High Court lacked jurisdiction on the matter, saying the judge should not have awarded damages based on his personal parameters. For now, it is not known if the judgment would be appealed, as efforts to speak with the spokesperson of Sunday Igboho were unsuccessful.
The inability of the federal government and ASUU to reach a common agreement after 6 months of a nationwide strike is not viewed kindly by the majority of Nigerians. The National Executive Council of the Union had, after an emergency meeting in Abuja, in a statement, announced an indefinite extension to its strike. The union had described its engagement with the federal government over the last 5.5 years as filled with a lot of deceits at the highest levels, as it found itself a fruitless and unending negotiation. The Executive Council also claimed that none of the issues that forced its union to resume the suspended strike has been satisfactorily addressed by the government, contrary to the claims of the Minister of Education, who had reduced the struggles of the union to the payment of retired salaries. This bitter unflinching stand by ASUU has stakeholders gravely concerned not only about just how long the strike will continue, but how the continuous stay at home will affect the Nigerian education system. For the Arawa transformational leaders, the indefinite strike will not only impact negatively on the education system, but will lead to more youth being forced into banditry, especially those in the north. They call on the federal government to reverse its no work, no pay sanction and get the union back on the negotiation table in the interest of the nation.
I portray evidence to prove that agreement between them and federal government are not meant. In a situation like that, one strike is not seen as any way of showing flexing torso between them and federal government. However, if we need to apply this, the children, which is the students, are going to whatever be the dispute, it is table discussion that is going to resolve it. So you don't penalize somebody that you are negotiating with ahead of conclusion and you expect him to comply with you. No, we are dealing with ahead.